and the pleadings which are to be written as far as those mortgages are concerned, we are only left with two mortgages, that is anomalous mortgage and mortgage by deposit of title deeds. Here, as far as anomalous mortgage is concerned, I already gave you the definition. It's an agglomerate or combination of two or more mortgages contained in a single document. It is called an anomalous mortgage. Here, it depends upon the contract or the understanding between the parties, and their respective rights and liabilities are also decided by that. And it is more than two mortgages contained in a single instrument. That is what is called an anomalous mortgage. For example, suppose let us say there is a date fixed for payment, and also the title is transferred, and subject to the condition that the debt has to be paid within a particular date, and if it is not paid, the sale will become absolute, and in case the debt is paid, the sale shall become void, and the property will be reconveyed back to the mortgagor. That is the essence of an English mortgage. Then you take the case of a usufructory mortgage, where possession of immobile property is delivered by the mortgagor to the mortgagee as a security, and the mortgagee will have to adjust his debt from out of the rents, share of crops, annuities, and profits arising out of the business. So it's a combination of two mortgages. There is usufructory mortgage as well as English mortgage. Then how the rights have to be worked out, it depends upon the various aspects. Here, the question is, what is the type of suit you file? Suppose you want to ask for delivery of possession, because usufructory mortgage, you deliver possession of the property, but title remains with you. But as far as English mortgage is concerned, title is transferred, but a date is fixed for payment, and if it is paid, and the property is also transferred, and in case the amount is paid within the fixed duration of time fixed in the document, the property will be reconveyed back to the mortgagor. I'm sorry. So it's a combination of two or more mortgages. How do you draft a suit? Please remember, for God's sake, don't draft a document called anomalous mortgage, because sometimes what happens is we become anomalous. We are not able to find out as to under what are the obligations under these two kinds of mortgages. So even assuming, since it is there, I'll just tell you how the suit is drafted. The other contents and all, you know about it. And then the question is, brief facts of the case is that on so and so date, the defendant approached the plaintiff. The plaintiff was approached by the defendant for a loan facilities under so facility, and that he promised to pay the money within a fixed duration of time, and also transfer the title in respect of the property, subject to the condition that if the amount is paid within the fixed duration of time, the sale shall become absolute, and the sale shall become void, and the property will be conveyed back to the mortgagor. And in the event of his failure to pay the debt, the sale shall become absolute, and the plaintiff was entitled to get the property sold through court. The original documents like promissory note, what is called receipt, then agreement, then mortgage deed, encumbrance, all these things are filed and marked so and so to so and so. Next para, that the defendant, as per the usufructory mortgage, delivered possession of the suit scheduled property to the plaintiff, and with the direction to appropriate the debt from out of the rent, share of crops, annuities, and profits arising out of the business. And since the plaintiff gave such a defendant gave such a right to the plaintiff was collecting the rents in respect to the property, and was to deliver possession only after the entire debt was satisfied. The original mortgage deed is filed and marked as document number so and so. Next para, that on so and so date, the plaintiff, through his legal notice, called upon the defendant to pay the suit amount within the stipulated time. The defendant received the notice but did not send any reply. Office copy of the notice and the postal acknowledgement are filed and marked so and so. Then particulars of the mortgage, I told you, name of the mortgagor, name of the mortgagee. Then next one is amount of the loan. Then fourth one is the rents collected. Then interest charged. Then the description of the property that is delivered. Then another thing is a less amount recovered, plus in the last column will be the amount receivable. Then after that, cause of action for the suit arose on so and so date when the defendant executed the necessary documents, and also on so and so date when the defendant was called upon through the legal notice to pay the suit amount. The next part, jurisdiction part of it. This honorable court has jurisdiction as the suit scheduled property is located at Hyderabad within the jurisdiction of this court. Then you say the suit is valued for the purpose of court fee and jurisdiction at rupees so and so, and a court fee of rupees so and so is paid under section 20, read with schedule 1, article 1B and C, TSSCV Act. Then next one is no suit is filed. Then after that, suit is within time, within the period of limitation. The real problem for you will come as far as the prayer part of it is concerned. The plaintiff therefore prays for a judgment and decree against the defendants as follows: 1. For payment of rupees so and so towards the mortgage loan with interest at 24% per annum from date of suit till date of realization. B is for sale of the property offered as security under the English mortgage, and C will be for cost of the suit, and then signature verification. Then after the list of documents which are filed along with the plaintiff, then the plaintiff signs, then the schedule of property which is offered as security, and the party also signs and verifies the pleadings, and it is filed into the court. Please remember, it's very, very difficult to draft a suit. As far as anomalous mortgage is concerned, you cannot decipher what are the rights of the parties. That is the reason now don't draft the anomalous mortgage at any cost. Then we go to the last type of mortgage popularly called mortgage by deposit of title deeds, or the bankers call it as equitable mortgage. Here I would like to make it clear that in India we do not have equitable estates. Our title does not pass in equity. India recognizes only what is called legal estates. Equitable estates are not recognized. Here, as far as the essence of mortgage by deposit of title deeds is concerned, where the mortgagor, mortgagor through conduct, implication, expressly deposits the deposit the original documents pertaining to his property as a collateral security for the due repayment of a loan paid, promise, part paid or part promise. It is called a mortgage by deposit of title deeds. Here, when we draft a suit, as far as this type of mortgage is concerned, the other paragraphs are common, sir. Fifth paragraph is brief facts of the case that on so and so date, the defendant approached the plaintiff for loan facilities under whatever facility it may be, and the plaintiff agreed to advance the said amount, and the defendant executed a DP note and received a DP note dated so and so in favor of the plaintiff. Full stop. Then you say the defendant also executed an agreement of cash credit money type in favor of the plaintiff and is dated so and so, and the same is filed and marked as document number 2. Then next para, that as far as that the account kept and maintained by the defendant towards the loan was regularly entered in the ledger, and COB, that is confirmation of balances, and the acknowledgement of debt was taken every quarter, and the revival letter also was executed by the defendant in favor of the plaintiff, and the same are filed and marked so and so to so and so. Next para, you say that since the defendant was not paying the suit amount, the plaintiff through his legal notice called upon the defendant to pay the suit amount. The defendant received the notice but did not send any reply. Office copy with the post acknowledgement are filed and marked so and so. Next para, what you mentioned is this honorable court has jurisdiction to try this suit as the suit scheduled property which was offered as security is located at Nalgonda within the jurisdiction of this honorable court. Next para, the suit is valued for the purpose of court fee and jurisdiction at rupees so and so, and a court fee of rupees dash is paid under section 20, read with article 1B and C, TSS CV Act. Next para will be the suit is within time and within the period of limitation as the original loan facilities was secured by equitable mortgage through deposit of title deeds on so and so date, and is therefore within time and within the period of limitation. And then next one is no suit has been filed in respect of the same claim in any court nor any suit is pending. The last paragraph, you have to be very careful when you draft the prayer. You say, for the plaintiff therefore prays for a judgment and decree against the defendants as follows. 1. For payment of rupees so and so due under the loan facilities with interest at 24% per annum from date of suit till date of realization. B. In default thereof, a preliminary decree for foreclosure for enforcing the charge on the suit scheduled property through sale under section 30 under section Article 34 Civil Procedure Code. Please remember, when you draft a money suit, there must be a paragraph devoted for name of the mortgagor, name of the mortgagee, amount sanctioned, interest charge. Then question is description of the property that has been offered as security, and then last one is the boundaries of the property that has been shown as security, and then the less amount paid and the actual amount due and payable. This paragraph has to be compulsorily mentioned in a suit for mortgage, especially in the case of mortgage by deposit of title deeds. And please remember one thing, again I'm repeating, saying that all suits under the mortgage are filed under a special order called Order 34 Civil Procedure Code. Order 7 does not apply as far as mortgage suits are concerned. So this is as far as the 6 kinds of mortgages: simple mortgage, mortgage by conditional sale, English mortgage, usufructuary mortgage, anomalous mortgage, and mortgage by deposit of title deeds. They are concisely contained in a section called Section 58 of the Transfer of Property Act, and these kinds of mortgages are found in 58A to 58F of the Transfer of Property Act. And one important thing you must remember is every transfer of immobile property or any transaction relating to immobile property has to be in writing. Above the value of 100 has to be in writing and has to be duly registered. This is the provision, new provision 17(1)(b) of the Registration Act, which was introduced in 2001, effective from 1/7/2001. So with this, along with these 6 types of mortgages, I finished about 17 planes which I have discussed. Today we will discuss about a small provision called pauper suits. What do you exactly mean by pauper suits? Pauper suits are normally filed under the provisions of Order 33 of the Civil Procedure Code. What do you mean by pauper? Say a pauper means a person who does not have means at all, or a person has means but not sufficient means to meet the expenditure towards payment of court fee. In that contingency, he can request the court to permit him to file a suit in forma pauperis, IN space forma, FORMA space pauperis, PAUPERIS, and this is concisely called a pauper suit. Here, the name of the court, so on and so forth. All pauper suits are filed as OP, that is original petition of whichever year it may be between, and then the government has to be necessarily made a party as far as the pauperism inquiry is concerned, and the second is a contesting party whom you have made the defendant. And please remember, the same contents like a money suit, I'm like a title suit you file, but the only difference being in one paragraph you say the plaintiff submits that he has no means to pay the court fee and therefore requests this honorable court to permit him to sue as a pauper or in forma pauperis, and suitable permission may be granted to him. Then cause of action, etc., you mentioned like a suit. Then also you say this honorable court has jurisdiction. Everything is almost the same. In the last paragraph, especially the prayer clause, you clearly mention the plaintiff therefore prays that he may be permitted to file the present suit as a pauper for recovery of rupees so and so from the defendant with interest at 24% per annum from date of suit till date of realization. Then B is cost of the suit. Then the person signs, and it is also countersigned by the advocate, and verification is also done. And then the list of documents which you rely is also mentioned. And you also mentioned the schedule of property. That is, what are your belongings? What belongs to you? What is the worth of those properties, etc., etc. You mentioned. And in fact, OP is nothing but the verbatim replica of the plaint, which is going to be decided later. Then after that, notice is issued to the government pleader. Notice is issued to the opposite party. opposite party will be given the right to file liberty to file a counter, oppose a pauperism petition, and try to disclose what are the properties owned by you, which you have suppressed. Then, if the court, based on the evidence, finds that the plaintiff has no means at all, then permits him to sue as a pauper and postpones the payment of court fee till the end. And once the decree is passed, let us say, in cost is awarded, the government walks away with the court fee that is awarded by claiming it from the defendant. And please remember, in a pauper suit, there are two stages. One is what is called pauperism inquiry, another is called a regular suit. And then the OP gets converted into OS and regular inquiry is conducted. But please remember, after suppose, let us say, the court permits you to sue as a pauper. Later on, you acquire a property, and please remember, the defendant will be watching you with the like a hawk, and say and bring it to the notice of the court. Sir, subsequently has acquired property. Sir, he is in a position to pay the court fee. Please direct him to pay the court fee. If not, dispauper him. That is, withdraw the permission to sue as a pauper. Then in that case, if the court comes to the conclusion that the plaintiff has sufficient means which he has acquired later, then the court fee will have to be paid by the plaintiff at any cost. So these are the incidents and of a pauper suit. And along with that, you must also file an application for permission to file as a pauper, and necessary permission is granted by the court. So that is the 18th pleading which I have discussed. Then we go to what is called rectification suits. Rectification suits is covered by Section 26 of the Specific Relief Act. What do you mean by rectification? The word rectification comes from the word rectify. Rectify means correct, alter, or make the correct entry. That is what is called rectification. Here is the same court name, so on and so forth, OS number, party's name, then the other descriptions you give. And one thing you clearly mentioned, suit filed under Section 26 of the Specific Relief Act 1963. Then the brief facts of the case, you mention what are the documents which you want to be rectified. Then you say that the plaintiff is the absolute owner and possessor of house number so and so, admeasuring so and so, situated at so and so. And in the original sale deed, there are certain misdescriptions or the parties' misdescriptions as far as the schedule is concerned, misdescription as the survey number is concerned. All these things have to be rectified. Then you say the plaintiff called upon the defendant to execute a rectification deed correcting those mistakes, but the defendant did not give any response, and hence the present suit is filed. Office copy of the notice along with acknowledgement are filed and marked so and so. Then you say next para, cause of action for the suit arose on so and so date. When the document was registered, that is the cause of action. And subsequently, when the plaintiff, through his legal notice, called upon the defendant to execute a regular rectification deed, which he did not do so, and hence the suit, then this honorable court has jurisdiction to try the suit, as a suit scheduled property is located within the jurisdiction of Hyderabad. Then next one is you say the the rectification sought for in the present suit are as follows. Wherever the term Srimati is mentioned, mention it as 3. Wherever it is mentioned as 91 survey number, mention it as 91 by R, 91 by R. Then the parent document also you file along with the suit. Then the last part, then these are the rectification which you seek as far as the corrections that we made. And the revenue entries also, you will have to clearly mention what are the mistakes that have occurred, how your name has been deleted, how your name has to be included, and what are the corrections and what are the errors which have occurred in the parent document. And the parent document will have to be filed along with the suit. Then you come to the same schedule of property, so on and so forth, and then you file the suit. That is what. And please remember, the court fee which you pay in respect of rectification suit is under Section 43 of the Court Fees Act, and it's only 15 rupees, 15, which you pay as far as the rectification suit is concerned. Much of discussion and much of explanation is not required as far as rectification suits are concerned. Then we go to the most important type of suit called Suit for cancellation. Suit for cancellation is normally filed under Section 31 to 33 of the Specific Relief Act 1963. Then, what do you mean by cancellation? See, I think if you are aware of the Contracts Act, you got the vitiating elements of contract: coercion, misrepresentation, fraud, undue influence, mistake, unilateral, and bilateral. When these errors are, when the consent is not free and it is vitiated by these elements, the contract is voidable at the option of the party whose consent is not free. Of course, I have discussed in umpteen number of times what coercion means, so on and so forth. In these type of suits, what happens? One fundamental rule you must remember is only a party to the document can apply for cancellation. A person who is not a party to the document cannot apply for cancellation. This particular chapter deals with not only the cancellation of instruments but cancellation of decrees also. Here, I've also defined the word instrument. What is instrument? Instrument is anything, any stipulations that is contained in a sealed document or a registered document is what is called an instrument. An instrument from the point of an advocate is the sale deed, gift deed, so on and so forth. Here, let us say somehow one of the elements of the vitiating elements is present in your case. Then you say brief facts. You say that on so and so date, the plaintiff submits that on so and so date, the defendant under coercion induced the plaintiff to execute a registered sale deed bearing document number so and so, dated so and so, in his favor, and usurp my property. And the said document is also a fraud because my consent was not free. The original document, or the what you call the certified copy of the document, is filed and marked as document number one. Next para. That subsequent to the execution of the document, the plaintiff lodged a police complaint complaining about the illegal acts of the defendant, but the police authorities did not take any action but directed the plaintiff to approach a civil court. At any rate, the impugned document was executed by the plaintiff under suspicious circumstances, and fraud was played on him or coercion was played on him. And therefore, if the document is allowed to remain, it will cause enormous loss to the plaintiff, and hence the present suit. Next, para cause of action for the suit arose on so and so date when the plaintiff was induced by coercion to execute the registered gift deed in favor of the defendant, and also on so and so date when the defendant was called upon to cancel the documents and surrender the documents after cancellation, which he did not do so in spite of the legal notice, and hence the plaintiff has no other alternative than to file the present suit. The office copy of the notice with post acknowledgement is also filed and marked as so and so. And the original document through which the plaintiff was induced to execute the document is also filed and marked so and so. Next paragraph. This honorable court has jurisdiction to try this suit as the parties reside and work for gain at Hyderabad, and the suit scheduled property is also located at Hyderabad within the jurisdiction of this honorable court. Then after that, the suit is valued for the purpose of court fee and jurisdiction at rupees whatever is the value of the document, and then a court fee of rupees so and so is paid under section 20, read with schedule 1, article 1b and c, AP code, TSSCV Act. Then next para will be the declaration, that is, you have not filed any suit. Next para will be the suit is within time and within the period of limitation as it is covered by Article 58 and 59 of the Limitation Act. Next para will be the plaintiff therefore pays for a judgment and decree as follows. A. To cancel the registered gift deed bearing document number so and so, dated so and so, said to have been executed by the plaintiff in favor of the defendant through coercion. B. To restore possession of the property which was delivered through the impugned gift deed. Then C is for cost of the suit, and then the party signs and it is verified, and the advocate also signs, and then after that, if you file whatever documents you file the list of documents, and then after that you mention the schedule of property with the proper description, and the schedule also has to be properly valued. Then even if a decree is there, the same procedure applies. If you want to challenge a decree as being a fraudulent or as being what is called without your consent, or you are not made a party to that, and in spite of the party knowing that you are a proper and necessary party, you have not been impleaded, then in that case you can ask for that particular decree to be cancelled as null and void. Then the question arises, sir, in which court I should file? You should file it in the court which has got proper jurisdiction, or the court which passed the decree, the same court you will have to file the suit. The same contents you will have to mention, and the grounds on which you are attacking that particular decree, you will have to clearly mention. You say that the plaintiff respectfully submits that he was a proper and necessary party to the suit, and the defendant deliberately with full knowledge, though I am a party, though the plaintiff was a party, did not implead him as a party, but the decree, if it's allowed, the judgment and decree, if it's allowed to continue, it is going to cause enormous loss to the plaintiff, and hence the present suit is filed for cancellation of the decree. Then, as for the other clauses, then what happens is the party signs, which is countersigned by the advocate. Verification is the list of documents which you file along with the suit. You also mention it, and then after that, you mention the schedule of property, which is covered by the decree, and then proper verification as far as the schedule is concerned. Then, of course, all other things like verification affidavit, then affidavit under Order 6 Rule 14 for verifying, saying that the addresses mentioned of the parties are true and correct, and then you file the docket, and then Order 6 Rule 15, verification affidavit, Order 6 Rule 14, you mention the addresses and say that the addresses mentioned are true and correct. So that finishes the pleadings as far as cancellation of instruments and decrees. So now what we'll concentrate on the interaction time, because yesterday and day before, due to certain unavoidable circumstances, we could not hold the class. Where today we are having a lengthier interaction till 8:15. Any person having any doubts or questions are free to ask. Yes, please start, please. Yes,
Yes,
please
please
proceed.
proceed.
Any questions, please? Mute చేశారా? Please unmute your mics and ask the questions, please. Or else the interaction is postponed till Sunday. Whatever doubts you have got, kindly get it cleared on Sunday, please.
No, no, it's daily. They want it daily.
Carry on with the. We have already made the house open. You can ask questions, please.
Any questions for today, or can we conclude the day for today?
Hello?
Yes, please go ahead.
Sir,
Yes,
there is one question, sir.
you're
What
welcome.
is it?
Yes, sir.
Uh,
Please go ahead.
one builder taking the land for construction of flats
Development.
development
Right,
with the landlord.
right.
What happened here is means
Hmm.
the builder without consent of the landlord, whatever the flats divided to each other,
Right.
that builder has without consent of the landlord, he mortgaged some flats to the bank.
Okay.
Then this is a case he will not respond to the landlord's questions.
Right.
Then what is the
Remedy for you is
Yes.
remedy for you is you just go through the development agreement whether the developer has got the right or liberty to mortgage. Number one, in case he has got that right, what steps he has to take? Should he take the owner into confidence? Three, at any time did he inform the owner that he is going to mortgage and raise funds? If he has not taken, it gives you a right of filing a suit for cancellation of the development agreement. And then, of course, the question is, consequently, you must also get that what you call the credit facilities which he has obtained from the bank. Because the question was, as far as his share is concerned, only to that extent it will be valid, not otherwise. Are you able to understand, please?
Yes, I understood.
Yeah.
But without consent of the landlord's share,
that's the reason.
the builder has himself. There is no agreement in the development agreement.
See, sir, if you see the development agreement, the dangerous thing there is GPA is also executed. So the question is, the developer has got full powers to even mortgage the property or offer it as security because he has to raise finances, isn't it? But here, if he has not taken the consent of the owner, then it's a lapse committed by him. It gives you an option of giving a notice, cancelling the development agreement so that he may come with bended knees and settle the matter with you.
Okay. But he did not come to the discussions. He is avoiding the.
That's the reason why you give a legal notice.
Okay. Legal notice is enough, no?
No, legal notice, and then after that still he doesn't respond, then you file a suit for cancellation of the development agreement itself. Because the bank will be at his throat again.
Cancel the development agreement.
Cancel the development agreement. Definitely will come for a compromise.
I see. Because age restriction, landlord is not able to do such action against him.
Even if then he can nominate a power of attorney to do certain things on his behalf.
Okay, sir.
For notice, is presence is not required, sir.
Presence is not. Thank you.
Just a minute, sir. Sir, yes, next, please.
Sir, good evening, sir.
Good evening.
Sir, the long back, the sale deed is executed by the one person. He is the owner of that property.
Right.
Self-acquired property is, under partition, he got the property and executed sale deed.
Yes.
But subsequently, after execution of sale deed, but actually, this is actually partition. Even though partition morally, but in the recitals, they added that it is the joint property, even though it is individual property of so and so. But to future complication, if you do not know, that is the reason the other persons, the brothers and other persons, to be added
as consenting parties. Consenting parties.
Yes. And subsequently, after execution of sale deed,
right,
they put it as a they write it as joint.
Right.
in between the property is the one joint property like that. Joint is added subsequently.
Okay.
How to come out from that, sir?
The question is here, but sale deed has already been done.
Done.
If it is written there, no one can do anything. But the question is, if it is a description there, since they have signed as consenting parties, is not going to have any effect, sir.
But consenting parties, if it is non-required, they also think signed.
Say that means they have no objection for that.
But the problem is
the joint property.
Yes. Actually, even they are individual property of the vendor,
right.
They said it is joint property, and subsequently the litigation will start with the entire extent.
Do one thing. Then under section 26, the real intention of the parties was not shown in the document. Instead of mentioning it as self-acquired, it has been mentioned as joint property, which will have wider repercussions later. Please get the said word joint removed and use it as self. You can file a suit for rectification.
Rectification, yes, rectification.
Section 26.
Actually, subsequently, they filed the rectification, stating, directing, asking to direct the registrar to consider for doing this.
They will not do it, sir, unless you file a suit.
He will not do it. He not do it after sending notice and to the opposite person to do the needful. Yes, but it is not. It is not.
Earlier they used to do it, but now they are not doing it. And section 26, you will have to go to a civil court, get it rectified, and file the parent document so that the necessary, and also a direction to the SRO to make the necessary corrections.
Sir. Yeah. Okay, sir. Rectification.
Yes, sir.
Okay, sir. Thank you very much.
Sir, doubt sir.
Chapani.
అయితే ఇప్పుడు ఇద్దరు కలిసి ఒక భూమి కొన్నారు సార్. ఇప్పుడు ఒక ఎకరం అట్లా అనుకోండి.
ఓకే.
అయితే ఇద్దరు కలిసి జీపీఏ వేరే వాళ్ళకి వేశారు. అయితే ఇప్పుడు ఇద్దరు ఇట్లా ఒకరు జీపీఏ క్యాన్సిల్ చేసుకోవాలనుకుంటున్నారు. అట్లనప్పుడు ఏం చేయాల్సి వస్తుంది సార్?
See, the entire GPA has to be cancelled. One cannot cancel it without the other because it's a joint GPA which has been executed by two people in favor of a single GPA. The entire document has to be cancelled. The fresh document, whomsoever remains, he can execute a GPA in favor of that person.
అయితే ఇంకో అదర్ పర్సన్ ఇంట్రెస్ట్ లేదన్నమాట జీపే క్యాన్సిల్ చేయడానికి.
Then you give a notice to the GPA holder. Why do you want to cancel the GPA?
అంటే ఇప్పుడు వాళ్ళు ఏమనుకున్నారంటే ఇప్పుడు జీపే హోల్డర్ కి ఏం చెప్పారంటే మీరు అమ్మి అమౌంట్ ఇవ్వండి అని చెప్పారు. అయితే ఇప్పుడు సెకండ్ పర్సన్ జీపే హోల్డర్ వైఫ్ అండ్ హస్బెండ్. ఎవరైతే ఇప్పుడు జీపే క్యాన్సిల్ చేసుకోవాలనుకుంటున్నా అతను వేరే వాళ్ళ తమ్ముడు. అయితే ఇప్పుడు అమౌంట్ ఇస్తలేడు అనమాట.
Give a notice saying that I will be compelled to get the GPA cancelled. If not, the only alternative for you would be to file a suit for cancellation, sir, under 31 to 33.
Okay, sir.
Yeah. Yes. Yes, Mr. Sam.
Sir, good evening, sir.
Good evening. Please go ahead.
Sir, just wanted to ask, what are the due diligence before entering the development agreement, sir? What are the preventive measures that we have to take before entering into a development agreement? It is a follow-up question to first question.
Preventive measures you take in case of a development agreement is earmark the respective shares of the owner as well as the developer in clear terms, number one. Number two, also mention a clause that in case the developer deviates from the development agreement, option is given to the owners to terminate the development agreement without notice or with notice of 1 month or whatever it is. Third one is the developer will have to carry out his duties strictly within the four walls of the development agreement and shall not deviate as far as any clauses are concerned which may give rise to for cancellation. All these precautions you have to take. But when you draft it, better draft it twice or thrice and then try to consult your client and then make it final, sir.
About GPA, sir, any conditional things that we have to put?
See, normally The word they use is irrevocable GPA, sir. GPA, you can also say this GPA is only for a period of 1 year and likely to be and is liable to be revoked in case the job of the GPA holder is not satisfactory after giving him 1 month's notice in writing.
Okay, sir.
Yeah.
Thank you, sir.
Welcome.
We conclude in the class as of now today. We'll see you tomorrow again. Have a good day.
Okay, sir. Thank you.
Have a
Thank
good
you.
day.
Have a good day.
Thank you.